Chapter 16. Upper Civil Court. Outside sources are underlined in blue text. Forms available in our Forms package are underlined in red text. Links to each are below this video. Are you considering taking your dispute into the upper civil courts, the granddaddy of the courts which we refer to as the House of Horrors? Unless you are up for a dreadful experience, it is time to detour your dispute to Alternative Dispute Resolution, ADR, or Small Claims Court by following Master Plan 1. If you are unable to detour, Master Plan 2 in the next chapter, Upper Civil Court Mechanics, presents the soundest plan possible for the trip ahead. Master Plan Part 1, Detour. 1. Work your case through Lawsuit Analyzer. 2. Complete the steps in when and where to file my lawsuit. 3. Name your potential defendants. 4. Perform a collectability assessment. 5. Assess the possibility of a countersuit. 6. Follow the steps on the court website you will file in. 7. Decide whether to hire an attorney. 8. Prepare and send a demand letter to your adversaries. 9. Reconsider reducing your claim to the small claims court limit. 10. Engage in automated online blind bidding. 11. Submit a mediation arbitration proposal to your adversaries. Master Plan Part 2, Entering the Upper Civil Courts. 1. Know what to expect. 2. Representing yourself, know what it means. 3. Carefully plan your case. 4. Continually plan and re-evaluate your case. 5. Continually monitor your costs. 6. Propose settlement often. Some of the steps in this chapter appear in the Small Claims Court chapter. They are repeated here as they apply to cases entering the court system. Master Plan Part 1, Detour. Step 1. Work your case through Lawsuit Analyzer. Lawsuit Analyzer is the legal tool that transforms you into legal connoisseur through its 7-phase analysis. When you complete Lawsuit Analyzer, you will have a good understanding of how successful your lawsuit may be in terms of winning, the recovery you may net, and how likely you are to collect on your judgment. What you will not know, however, is how your trip through the House of Horrors will have a devastating effect on your life. This chapter hopes to impart this information to you since its focus is to deter you from entering the upper civil courts. Upper Civil Court equals House of Horrors. Step 2. Complete the steps in the chapter When and Where to File My Lawsuit. This important step determines which county and civil court to file your case in and whether your case meets its filing deadline. Do not miss in that chapter this step, especially the smart cookie tip in Step 3, which alerts you to the possibility of choosing a state with the highest case value limit. Do everything you can to squeeze your case into small claims court to avoid the House of Horrors and the litigation frenzy that accompanies it. Smart cookie tip. If you are headed for the House of Horrors due to case value, consider how much of your potential recovery you will give up to your attorney. Are you giving up 3 to 40% of your recovery? This factor may make it worthwhile to reduce your case value to come within the small claims court limit. Step 3. Name your defendants. You can sue anyone and every entity that you feel is responsible for your damages. But there is a certain recipe to naming your defendants correctly. The judgment you receive, if successful, will be in their name. You want it to be the correct one and have it match the assets you locate in your collectability assessment. See the chapter Identifying and Naming Defendants for more information on this subject. Step 4. Perform a collectability assessment. What about collection? Is there any guarantee that your opponent will pay your judgment if you win? Will you be able to collect through judgment enforcement procedures which will require more time and expense? Even if you have an attorney fee provision, you are still out the money unless you collect. You want to assess collectability up front before you file suit. If the court decides in your favor, it does not handle collection for you. So, before you sue, always weigh the feasibility of collecting on your judgment. When you worked your way through Lawsuit Analyzer, you should have researched your adversary's financial status, but take the time now to go deeper. Follow the steps in the chapter Collectability. Otherwise, your judgment could be an expensive piece of paper to remind you not to do this again unless you have a juicy defendant. Smart Cookie Tip. Lawsuit Analyzer performs a collectability assessment by asking you to choose your adversary's financial status from an extensive list. Step 5. Assess the possibility of a countersuit. Always consider that in most states your opponent has the right to countersue you if their claim arises out of the same event, which basically results in your becoming both a plaintiff in your case against them and a defendant in their case against you. In those states, if the defendant does not countersue, they give up their right to later sue you. Some defendants countersue just to gain leverage. So, if you are in a state that permits countersuits, do not be shocked if you have your defendant served and in response you are also served with their countersuit. Weigh the possibility that this will happen and assess whether it might be better to just let sleeping dogs lie if there is a likelihood that a counterclaim might be successful against you. Step 6. Follow the steps on the court website you will file in. Technology is certainly our friend when it comes to obtaining information, especially when it comes to the upper civil courts. Even if you've decided to be represented by counsel in your case, this step is important, so you are informed about the legal journey you are about to take as you head into the House of Horrors. Most states and counties have websites rich with information guiding you through the civil lawsuit process, including providing you with some forms to get your case started. In steps 1 and 2, you ascertain the value of your case and the court you will file in. Review available information on the state court site for where you will file your case, then go to the website for the court in the county where your lawsuit will be filed. Compare the two and use the one that is more detailed. Most states and counties have all kinds of self-help resources. Let's use California for illustration purposes. California State Court provides CA links to county websites. California State website is chock full of guidance. In CA civil cases filed in the upper court, called Superior Court, begin with a CA civil case cover sheet. Their CA Civil Case Basics page segregates their courts by case value. Small Claims Court if your case value is $12,500 or less. Superior Court Limited Jurisdiction if your case is worth $35,000 or less and more than $12,500. Superior Court Unlimited Jurisdiction if your case is worth more than $35,000. Case limits are always changing, so be sure to check these values before relying on them. Smart Cookie Tip. If you cannot locate an informative site for your state or county, call the county clerk's office where you will file your complaint and ask them the web address of their online portal for filing a civil case valued at more than the small claims court limit. Step 7. Decide whether to hire an attorney. Does it make sense to hire an attorney to handle your case? Your first inquiry to answer this question is, do you have an attorney's fee provision in a written agreement with your adversary? These provisions generally provide that if a dispute occurs, the prevailing party will be entitled to their attorney fees. Remember, this word entitled does not mean collect, it just means your judgment will include the attorney fees you paid. If you cannot collect on your judgment due to your opponent's financial status, you will not collect the attorney fees you paid along the way. Smart Cookie Tip. If you have an attorney fee provision, this provision is a two-edged sword because if you lose your case, you will be paying your adversary's attorney fees if they hire an attorney. If you think it feels awful to lose your case, having to pay your adversary's attorney fees to clobber you is double dreadful. Sometimes the provision says one party will recover their attorney fees. Most courts will treat this provision reciprocally, with all parties entitled to recover their attorney fees if they prevail. Be wary of the litigation frenzy. Be cognizant of the predisposition to the litigation frenzy which seems to attach itself to attorneys and sometimes litigants in the House of Horrors. Once the parties hire attorneys, the attorneys get set up for battle as they check their arsenals for available weaponry. Attorney weapons consist of expensive discovery procedures. Drawing a weapon before your opponent becomes a strategy. Each time one attorney unleashes a weapon, opposing counsel retaliates with a bigger, better, and more expensive weapon. A deposition notice summons up another deposition and an elaborate set of written interrogatories. The drums pound, the elaborate battle dance proceeds in stages, and each stage takes on grander proportions. A step through the archway of litigation causes court participants to become warriors in an escalating war. Litigation attorneys are fighters, a fierce combination of high-level intensity and adversity. This is a powerful and infectious combination. The blend of conflict and attorneys who advocate it produces a combustible mixture. A step through the archway of litigation causes even the most introverted participant to take up armor and sword and adopt the on-guard stance. Throughout the litigation process, the duel accelerates. This, we refer to as the litigation frenzy. It is not pretty, it is very stressful, time-consuming, and incredibly expensive. This is one of the major reasons we call the upper civil courts the House of Horrors, because of the litigation frenzy. Self-representation. Small claims court is set up for self-representation, whereas the upper civil courts are not. When your case value exceeds small claims or you are unwilling to limit your recovery to fit its value, you will be entering a complex, frenetic forum. Which court you enter depends on the state you are in and the value of your case, as was determined in steps 1 and 2. Self-representation is a fundamental legal right we all have. In the upper civil courts, self-represented parties enter at their own risk. Because the rules of these courts are many and complex, the upper civil courts are not set up for self-representation. An unrepresented party stands out like a sore thumb. In some attorney circles, unrepresented parties are considered prey to be taken advantage of. The wolves begin to circle. For these reasons, self-representation rarely works in the upper civil courts, unless you and your adversary have agreed to be self-represented. See our self-representation agreement. Smart cookie tip. If, after heeding this warning, you nevertheless decide in favor of self-representation, be armed with the information you will learn in the next chapter, Upper Civil Courts Mechanics, which provides you with tools for your journey into the underworld of litigation. Wisdom versus economy. Unless you are personally up for a great challenge, you will be hiring an attorney to represent you. Your choice of attorney is a key element to successfully pursuing your case. You want a team member, in every sense of the word. If you follow our recommendations, you and your attorney will be a team throughout your case. Refer to our chapter, Hiring an Attorney, to perform your most important job of hiring an attorney partner. If you do not have an attorney fee provision in a written agreement between you and your potential defendants, it may not make economic sense to hire counsel, yet it is probably wise to do so for the reasons stated above. Because upper civil court actions can take up to 5 years to get to trial and involve extensive discovery, attorney fees are generally quite high. Once you have begun, there is no escape outside of settlement. Be realistic about the expense you are about to take on. You should entertain a contingent fee arrangement with your attorney partner. You will give up a good portion of your potential recovery, but the arrangement will free you from paying as you go. With all of this in mind, if you are close to the small claims limit, reconsider reducing your case value, especially if you will hire an attorney. Very smart cookie tip. If you do not have an attorney fee provision, estimate how much you will spend on attorney fees, whether paid as you go or contingent fee arrangement, and reduce your case value by that amount. Is it closer to the small claims limit now? For these many reasons, you need to evaluate whether to hire an attorney very carefully, and if you hire counsel, judiciously manage your new team member. In the Hiring an Attorney chapter, we include several self-help tools in case you want to handle your case on your own. Step 8. Prepare and send a demand letter. Now that you are headed for the House of Horrors, a full-bore attempt to settle before filing suit is warranted. Prepare a demand letter explaining why you are owed this money, asking that it be paid within a specific time frame, such as 20 days, to be followed by a lawsuit if not paid. It should lay out the reasons why your adversary is liable for your loss, itemizing and substantiating the damages you are claiming. Go to our demand letter form for more information about preparing your demand letter, which should include a provision that the letter is not admissible in discovery or trial in a later lawsuit. Smart cookie tip. If you plan to hire an attorney, send the demand letter to your attorney for review or to use as a basis for their own demand letter, which would be taken more seriously than yours. With this type of written demand, your adversary will take you more seriously. They must now confront the very real likelihood that you plan to have your day in court against them. They must face the fact that soon they will have to expend money, time, and energy to publicly defend their position and possibly become liable for your damages. What was previously an unwilling adversary can transform into a willing one when faced with a written demand threatening litigation. Send the demand letter to your adversaries by a mail type that is tracked. Step 9. Reconsider reducing your claim to the small claims court limit. If Step 8 did not produce resolve, realize you are getting much closer to entering the House of Horrors. Again, reconsider reducing your claim to fall within the small claims court limit. Take the number you arrived at in Step 1 and chip away at it more. Smart cookie tip. If your case value is above the small claims court limit in a state where the dispute should be bought, if there is also a choice of another state, consider filing in the state with the higher limit. You may be able to appear remotely at the hearing. See Step 3 of the Where and When to File Your Lawsuit chapter for more. Step 10. Engage in automated online negotiation. If the demand letter does not resolve your dispute, consider automated online blind bidding. See the Alternative Dispute Resolution and Mediation chapters for more on these platforms. This type of negotiation is available to anyone wanting to resolve a legal dispute that can be addressed by the payment of money. It is really worth a try. What is there to lose? Blind bidding could be just the thing to get your dispute resolved at the beginning, in the middle, or at the end, where other processes have failed. It is a voluntary process, so you will have to obtain your adversary's consent. Step 11. Submit a mediation arbitration proposal to your adversary. If the above options do not resolve your dispute, submit a mediation arbitration agreement to your adversary, or skip Step 10 and submit the multi-step alternative dispute resolution proposal instead. These out-of-court processes are voluntary, so you will have to obtain your adversary's consent. Smart cookie tip. Transmit your agreement of choice to your adversary with our Alternative Dispute Resolution Agreement transmittal letter. The convenience of online alternative dispute resolution. You and your adversary might choose alternative dispute resolution just for its convenience factor, since both mediation and arbitration can be held entirely online at the convenience of the parties, something you cannot do in the House of Horrors. The Alternative Dispute Resolution chapter deals extensively with online proceedings as opposed to in-person. The privacy factor. Your adversary will also be motivated to engage in alternative dispute resolution due to its privacy factor, in contrast to the public court system where disputes are publicly aired and can be looked up online. These issues are addressed in the compelling alternative dispute resolution transmittal letter previously mentioned. Why are you going to the House of Horrors without first going to mediation? Mediation only makes sense. If you haven't been to mediation, remember to keep asking yourself, Why am I filing suit when the court is just going to refer me out to mediation before it will hear my case? It is a really good question. It has got to be that you or your adversary is pig-headed. The court you are about to enter requires disputing parties to engage in mediation before they litigate. Now, except in small claims court, in nearly every state, a court-ordered alternative dispute resolution referral follows the filing of your lawsuit. The intent is to catch your case before cost and emotion make settlement more difficult. Most often, the case resolves in the alternative dispute resolution process. If it does not, it proceeds forward through the upper civil courts. Smart cookie tip. When you understand this, it would be nonsensical not to do so now, especially since mediation has an 85% success rate. This is how the process goes in most states. A California Alternative Dispute Resolution Information Package is served on your defendant along with your lawsuit. This package informs the parties that the courts will not hear their case until alternate dispute resolution methods are pursued, to encourage the litigants to utilize out-of-court methods to resolve their disputes from the get-go. If the parties have not engaged in alternate dispute resolution by 3 to 6 months later, when most courts hold a case management conference, they are referred out to alternate dispute resolution by the court. See California's case management statement. Review these documents even if California is not your state, so you can be informed of the big push the courts give to resolving a case in mediation instead of in the House of Horrors. Your state probably has a similar ADR referral. It really does not make good sense, then, to skip pre-litigation mediation at this point, since the court will just require you to engage in mediation before it will hear your case. We are recommending here that you present an alternate dispute resolution proposal that also includes arbitration in case mediation does not produce resolve. If you and your adversary cannot agree to replace the House of Horrors with arbitration, just agree to mediate at this point. Smart cookie tip. Explain this to your adversary, giving them this link to this upper civil court chapter, since it will obviously be foolhardy for all of you to go to the expense of filing and responding to a lawsuit, and most likely hiring attorneys, when your dispute will just be bounced into alternate dispute resolution by the court. Master Plan Part 2, Entering the Upper Civil Courts. Assuming Master Plan Part 1 has not resulted in your dispute settling or moving into alternate dispute resolution or small claims court, you have got a huge job ahead. Move on to the next chapter, Upper Civil Courts Mechanics, for the roadmap to bring your dispute in the House of Horrors.